So hi, I'm David Glazer, and we are going to talk about peer review. So first, just a couple of announcements. We really, I think, only have two, which is the first, our next webinar, which will be Wednesday, February 11th, is going to be a grab bag topic. I think those are some of our best, are the grab bags. It's going to be on electronic health records and what should keep you up at night. So Briar Andreessen, Katie Ilton, and Jim Platt are going to talk about the issues that hospitals and clinics deal with related to electronic health records. Questions like, how do you deal with the pull-forward, copy-paste problem? How do you deal with a surveyor and their issues with an electronic health record? What do you do when a person leaves? How does that relate to the meaningful use payments? Scribes and signatures and logins, vendor contracts, basically all the stuff that comes up with an EHR in just sort of a general Q&A format. So that's next month. The number one complaint we get on our evaluations is always bad sound quality. And there's one part of that that's my fault, which is talking fast. But if we break up, that's sort of outside of our control. Remember, you can dial in. Chad's putting the number in the box. If you have a sound issue, if I sound crackly or disappear for some period of time, dial in. It's probably the internet being slow, and unfortunately, I do not have the power to fix that. The only other announcement is that, remember, you can always get all of our past webinars at this link. It should be in your materials as well. They're on SlideShare. It's difficult to use SlideShare. I shouldn't defame it, but it is hard to sort through there. But I think the easiest way to find the list is on our website, and all of our past webinars you can listen to there for free. All right, so let's dive into peer review. This is one of the hardest talks I think I've ever given. And the reason it's so hard is it's extraordinarily state law driven. And we literally have people on this webinar from Hawaii to Maine and Florida to Alaska. And each state has its own gig. And so I struggled a little bit with how to make this coherent. And what we're going to try to do is we're going to talk about examples from various states and hopefully some tips that will be useful for people to figure out what to look for as you look in your state statute. So one question, and just for people who dialing in some ways this is more targeted at clinics. There is definitely stuff that will be useful to hospitals in here, especially at the beginning. So why do peer review? Well, Bloom County teaches us a great deal about life. I really liked Burke Breathed, who did Bloom County. I know our son is hooked on his books. So he had a column, Steve's Law Tips, number 29, Who Should I Sue? So it's a little blurry, but we've got Steve sitting in his chair. Good morning. Today's tip is on effective suing. Let's look at my own recent example. On April 17th, the plaintiff, me, was brutally attacked by actor Sean Penn after I accidentally, and not on purpose, snapped a picture of him. The question, who should I sue? Sean? No, juries love famous people. Plus, he'd probably return to beat up the plaintiff again. Never sue psychotic celebrities. Sean's wife? No. True, living with Madonna might make most anyone irritable, but proving liability would be difficult. Plus, she too might return to beat up the plaintiff. Opus? No. Although he got the plaintiff into this mess, he's also dead broke. Never, never, never sue poor people. Nicolta Camera Company. Yes, a major corporation with gobs of liquid cash. It was criminally negligent in not putting stickers on their cameras which read, warning, physical injury may result from photographing psychopathic Hollywood hotheads. I plan to ask for $10 million. America, land of the lawsuit, God bless her. And that, in a nutshell, is why you do peer review. The duties that you owe in the healthcare world are numerous and, frankly, ever growing. Some of them are obvious. Obviously you have a duty to patients. That's the straightforward one, to your patients. You also, though, are going to have a duty to your professionals. You're going to have a duty to treat your professionals fairly. If you treat one of them poorly, they're going to be able to sue you. Those two, though, I think are pretty common and easily thought about. Some of the others, I think I would have said not all that long ago, you don't necessarily have a duty to, but the law is evolving in such a way that it looks like you might. So one of them, other patients in the community. Do you have a duty to someone who hasn't walked in your door? And increasingly the case law is suggesting you might. There's a concept out there called negligent credentialing. And it's taken primarily in the hospital world and also in the insurance world, and it's the idea that letting a physician practice improperly is itself a potential problem. And Excuse me while I drink some water there. One of the things about negligent credentialing is it sets up the idea that failing to get someone off of your staff, whether you're a hospital or a clinic, or giving them the ability to work there creates liability. There's a related possible theme. If you let someone leave your practice and go someplace else and you don't tell them about problems that arose while they were with you, that potentially may allow, there are now cases suggesting that you can have liability, and that a hospital and clinic that gets a doctor that used to be on your medical staff or in your clinic can sue you for your failure to warn them about that doctor's quality problems. There was a big case in Nevada involving a dentist who failed to sterilize his instruments. And the insurance company in that case faced large liability for not kicking the doctor out of the panel. It is now possible that insurers will try to argue that you have a duty to them to protect them and keep quality people out. So all of these duties are out there running around. Quality is increasingly a focus within the healthcare world, both in the sense of they're trying to put reimbursement disputes and say that in a reimbursement dispute, quality matters, and then also just in other peer review contexts. So why do you do peer review? It can make some awkward conversations a little bit easier. And conversations that you really should have. In the clinic setting, it may improve your employment review process because it lets you look at whether someone is a good physician or not. And it can definitely improve your risk management strategy and become a key part of it. So I am a big fan of doing peer review. I'm amazed at how few of our clinic clients have a formal peer review process or a peer review process. I shouldn't have used the word formal for reasons we'll explain in a couple of minutes. So what is the peer review privilege? And we'll talk a little bit about privileges generally here. And as we're going to say in a moment, this is really important. I don't think there is a peer review privilege. I think it's a peer review protection. But let's talk about this. So there's a concept in the case law called the critical self-examination privilege. And it's the idea that we want to encourage organizations to fix their mistakes. And so to facilitate that, if someone does self-scrutiny, some courts have said that the act of looking at your own behavior can't be used against you. You can think of it as akin to the Fifth Amendment, where nothing you say can be used against you. The Fifth Amendment obviously only applies in a criminal context. It only applies to individuals. It doesn't apply to entities. So it's not a perfect analogy, but it's the idea that if you, try to figure out why your floor was slippery and you conduct a thorough investigation to figure out how to prevent a slippery floor, we don't want that to be used in a slip and fall case against you. The critical self-examination privilege is often rejected by courts. It's by no means guaranteed to carry the day. But there is a federal law out there applying to peer review. That's called the Healthcare Quality Improvement Act. We're going to talk about that one in just a minute. Now, it's a weird law in a bunch of ways, and one of the things is it primarily applies to protect people from claims by the person who is the subject to the review. So it's primarily aimed at protecting the organization, the clinic or the hospital, and the participants in the process from a lawsuit by the physician who is subject to the review. So that's the Healthcare Quality Improvement Act. We're going to talk about that at length. Then every state and the District of Columbia has a law. Those laws are are all over the board, but one thing that's quite common in them, they generally apply to claims by patients against the entity. And so they're designed to say that a patient can't sue you, or if the patient can sue you, but they can't use information that was in the peer review process against you. Now, it's not going to say that original information that was generally available becomes protected because it went through the peer review process. And it's just like all other privileges, or like most other privileges, like the attorney-client privilege. If you have an incriminating document and you send it to Katie Ilton here, the fact that document's still discoverable. The fact that you sent it to Katie isn't discoverable, but the fact that the document exists is independent and the document doesn't become privileged because at a later point you chose to send it to Katie. And so similarly in the peer review context, you're not going to be able to have the medical record won't be privileged because that is out there. It exists. It's a free-floating document. But your opinions, if you put it through the review process, that's something that might get protected in most states. And so the opinion someone offers about the record is what will be protected. Now, within these state laws, we'll look at them. They're really technical. They're really hard. They're often very poorly written. They give me a headache, and I often feel humbly stupid reading them. So that's important to understand. Now, it's easy to zone out in one of these things. There are going to be sections where you probably could zone out. Pay attention now. This is, I think, the most important thing I'll say today. I think it's a mistake to refer to the peer review privilege. I prefer to refer to this as a peer review protection. Why, and what's the difference? Well, first of all, in many states, it's actually illegal to produce peer review information. It violates a law. In some states, it may be criminal, at least a misdemeanor. In others, it's just illegal, and so that it's wrong, okay? Privileges, generally, it isn't wrong to release the information. At least the person who holds the privilege is free to waive it. So think about this in the attorney-client context. If we send you advice, and you have this little letter from Fredrickson and Byron, you're free to give that letter to whoever you want. It's just that if you give that letter to someone else, the odds are it's going to waive the privilege, and that information is now discoverable. There are exceptions. You know, if it's there might be a joint defense agreement that would protect it, or some other common interest. So maybe there's an argument it's protected. But generally, if you share legal advice, the privilege is waived, and now you can't claim it in any future situation. Well, I don't think that's true for peer review. And actually, I shouldn't just say I. This is something we've talked at great length about in the group. And we've come to the conclusion that we think that this is a peer review protection. And that even if the information is released inadvertently or intentionally in a particular situation, that doesn't mean it should be allowed in other situations, because unlike a privilege, it's a protection and not subject to waiver. So that's kind of an interesting, nuanced point, and you don't hear it a lot. But so this is a semantics thing. I try to call it the peer review protection. I'll slip up. I'm sure I'll slip up in the course of this webinar. Now, I've been thinking about this stuff a lot. Oh, so this matters a lot in all kinds of ways. So one of the reasons it matters is that federal courts are often hesitant to apply state law privileges in a state law court action. So there's a concept in the law called comity, which is C-O-M-I-T-Y, not comedy, something which I would love to be good at, but am not. So comity is the idea that federal courts will generally defer to a state court's laws. But there's an exception for privileges. And in the federal courts, basically there's this, one of the rules of federal evidence, for those of you who are lawyers, Rule 501, that says unless the Constitution or a state statute or the Supreme Court has said that a privilege, a state law privilege, applies, generally in a federal matter, state law privileges aren't going to apply. And so that's out there. And it will allow people to try to say that at least if you're in a federal court, say maybe in a false claims action or something else, but if you're in a federal court for reasons other than diversity jurisdiction, which is how you get there when people are living in different states, the state law privileges aren't going to apply. And so they could try to say peer review doesn't apply. But if peer review isn't a privilege, then that principle shouldn't apply. And there's a better argument for the protection applying in a federal court action. And I haven't seen a lot of cases where I haven't seen cases where that's been applied, but I also haven't really seen that argument being made. So that's kind of one point. And then the other thing is the waiver notion that if for some reason you release the information, if it's a protection, that doesn't mean it's released again. The other thing that's important to note is because it's a protection, you may not have the ability to waive it. So there's a reported case out there where the Cleveland Clinic was in a situation where it got I believe it was a subpoena from in a criminal investigation, and it turned over data. And the physician whose data was ultimately turned over said, hey, you can't turn that data over. And the clinic's position was, well, of course we can. It was a criminal investigation. It was proper to turn it over. And the court disagreed and said they weren't supposed to have turned this information over. And it is unclear. So basically, there are arguments that it is illegal for you to turn over peer review data. And so one of the other important points is my personal advice and recommendation is if you get a request for something that you think is peer reviewed data and you're in a state, like many of them, that limits the ability to turn over the data, I think you have a duty to object to the subpoena. I don't think you can just willy-nilly turn it over because I don't know, it's not clear to me that you can waive this privilege. I think you may have a duty to protect it, and I would want to punt to a judge and let the judge decide what we're going to do. All right, so hospitals have to have a peer review process, and that comes out of basically the Joint Commission obligations, Medicare requirements. You have to have a peer review function if you're a hospital. Clinics don't have to have one, and many have not. I think it's useful to have, but there are some potential downsides, and we'll talk about them. So let's start off with the federal law, which is the easier one to look at. It's the Healthcare Quality Improvement Act. That Q to me looks actually like it's almost, I think that's the women's sign. I'm thinking like we're walking into the women's room here or something. But all right, people in the room are rolling their eyes at me. I don't understand. So this is a federal law. And it's a federal law that focuses primarily on antitrust or anti-competitive concerns. And you may think, what the heck are the anti-competitive concerns in peer review? But if you think about it in the hospital setting, you've got 3 physician groups in town. And the doctors at Clinic A are reviewing this. Let's make it a solo doctor at Clinic B. And so they're looking at Dr. B. They have arguably every incentive in the world to say that Dr. B is incompetent. Because if Dr. B is incompetent, their competition leaves town. And so this is a very real world problem, especially for hospitals. Now, it's worth noting, in theory, you can have this same issue in a clinic. 2 colleagues, hopefully they're not competitive, but they may think of themselves as competitive even within a clinic. Personalities can get there. But it's certainly a clearer one in the hospital setting. So the Healthcare Quality Improvement Act is designed to say we recognize that antitrust problem is there. So if people are acting in good faith, we're going to create some legal protection, and here's how it's going to work. So if you're a hospital or you're an entity is going to include a health maintenance organization, and you provide health care services, and you have a formal peer review process, and I've underlined that because the formality is going to matter. Or also, I guess this is almost an or you're a professional society, and professional society specifically carves out anyone who got nailed by the FTC for being anti-competitive. And since we don't have any professional societies on the call, we'll focus on clinics or hospitals. You can get this protection. So what's a formal process? Well, the regulations define a formal process as using a formally adopted written procedures which provide for adequate notice and an opportunity for a hearing. So one of the key things here is you have to have a hearing. Unless you have a hearing process, you do not have a formal process that meets the Healthcare Quality Improvement Act. And so if you're a clinic, you have to make a choice. Now, you may want the protection of the HQIA, but you may not, because if you have the protection that comes with this, there's also a duty, and that duty is to report to the National Practitioner Data Bank whenever you take a disciplinary action. And clinics sometimes would prefer not to have to report. Now, we'll come back to this in a little bit, because there are times you may have to report anyway. But if you want to get the protection of this federal law as a clinic, you need to have a formal hearing process and written policies. If you opt not to, if you're just going to use state law, you don't need to have a hearing process. So the Healthcare Quality Improvement Act defines a review action, and we'll talk about that definition in a couple of slides. And then it says that if you are the body itself, or any person who's acting as a member or who's staffing the body, Or you're like a consultant. You're someone who's under a contract or has some other agreement with the body. Or you're a person who participates or assists the body with the action. You can't be liable in damages under any law of the United States or any state with respect to the action. So if you think about this, this is really broad. So for these people, the people who are in the process and who are participating in the process, you can't face liability under any law except it then carves out a bunch of civil rights laws. And this becomes a big deal because there are all kinds of federal cases where a physician argues that he or she was being discriminated against on the basis of race or gender or some other civil right basis, and so that the disciplinary action in the peer review process was really on a religious ground or something else. They were being discriminated against because they were a minority. The Healthcare Quality Improvement Act doesn't protect you under those statutes. So that's just an important thing to note. So an action, as defined by the law, is anything that's based on your competence or professional conduct. But then it has some interesting exclusions. So the first one I don't think comes up very much, which is your association with the professional association. But if it's anything that's fees related or advertising or related to the solicitation of business, that kind of review isn't covered by the Healthcare Quality Improvement Act. If it's anything related to delivering basically your participation in employment, which is sort of weird and interesting. And this one really shocks me. If it's related to your supervision of or delegation of authority to like a physician extender or another professional, that's deemed not to be part of your professional competence. And that seems weird to me because that feels pretty professionally competent, but the statute specifically pulls it out. And if it doesn't relate to your competence generally. So those things are all out, which means that if you do a review, you're not going to get the So if you're looking at fees, for example, you can't use the Healthcare Quality Improvement Act as your protection. Then in the law, there's this paragraph, and this is an interesting paragraph because I think there's at least an argument I wouldn't be embarrassed to make that this protection applies more broadly than the Act itself. And it says that notwithstanding any other provision of law, no one, if you're a witness or anyone else, if you provide information to a peer review body, you can't be liable, once again, under any law of the U.S. or any state, unless the information you provided is false and the person in question knew it was false. There's at least a colorable argument that this provision applies more broadly than just to entities that meet the test of the Healthcare Quality Improvement Act. The way it's defined is it's providing information to a professional review body, and that term, the professional review body, isn't really defined. And so I think you could make an argument that even if you aren't acting as a review organization for purposes of the law, this paragraph creates protection. And I don't know of a case examining that. I just know I wouldn't be embarrassed making that argument. So this is an interesting thing out there with a really broad protection, and it trumps all federal and state laws. So in order to get the protection, you have to believe that you're acting in furtherance of improving the quality of health care. You have to make a reasonable effort to obtain the facts. You have to have notice and hearing. And so what the fights often come down to is whether someone is reasonable or not. So if a doctor is trying to say, hey, you were being unfair to me, they're going to say, well, you didn't make a reasonable effort to obtain the facts, or you were motivated by something other than quality. Now, they're going to have a burden to meet there, and the burden is that a review action is presumed to have met those standards unless that presumption is rebutted by a preponderance of the evidence by the person who's claiming they've been wronged. Okay, so there's a burden of proof on someone who wants to bring a claim against a review body. So that's the federal law. Now, the state law. And this is the hard part because I don't know how to present the stuff for 50 states, but I'm going to try to give some of the things that pop up. So these laws generally are targeted at keeping patients from discovering what happened in the peer review process. Once again, they're only going to protect deliberations of the committee. They're also will protect documents that are created by the committee. And so we'll talk about incident reports, for example. And if you create an incident report and fill it out, I think there's a pretty good argument in many states you've got a protection. But compare that to a situation I'm familiar with where a nurse wrote a 9-page delivery note and wrote everything that happened in there in the medical record. That ain't privileged, all right? That's just a medical record. If she had done the same thing on an incident report, perhaps a different story. Now, super, super important point. Almost every state will let the practitioner review the data. And I think I skipped a comment on one of my earlier slides. This is interesting. The protection here is really, it's not a social protection. It's if you were going to explain this to someone, you might say you want to make it easy for people to engage in the tough conversations. And so you want Katie to be able to say, David is a jerk at work, and he's really hard to work with, without me ever knowing that she said it. And conceptually, that's what you'd think the peer review privilege is designed to do. But in fact, that's not what it does. In the peer review setting, if I ever challenge as the physician what happened, I'm probably going to be able to find out who said what. So it's kind of a weird protection. What, especially in the States at least, I'm going to be able to find out who said what. What isn't going to happen is a patient isn't going to be able to find out that Katie thinks I'm a twit. That's the protection we're really going to get. All right? Now, what about the medical board? Can the medical board come in and say, I want to see all of your peer review stuff? Well, that's totally up to state law. And it looks like Kansas, Wisconsin, and South Dakota are 3 states. There were some we knew, and so I'm throwing some in here. This isn't to say that there aren't others, but those were 3 states that explicitly let the board get medical access to data. There are some things get really weird. So, for example, Minnesota law, Minnesota requires you to remove patient identifying information before you give information to the board. It's kind of strange, but unless the board has a release, you can't just send a medical record to the board. You got to take out all the patient identifying information. And so you got to look at what your state says. Now, this next part, I picked Nebraska. I could argue it's the middle of the state, or I'm sorry, the middle of the country, and that's why I picked it. Sorry, Kansas. But actually, it was because it's one of the hardest laws I've ever seen. And I'm going to build a little bit of a straw man here, because I think there's a giant lesson to be had if you follow this statute. And it's a lesson that could be used by lawyers and non-lawyers alike. So Nebraska says that a peer review committee is a utilization review committee, a quality assurance committee, a performance improvement committee, a tissue committee, or anyone else that's established by the governing board of a facility, which is a healthcare provider. Okay, so now we've got defined terms floating around like mad. We've got a governing board, a facility, and a healthcare provider. Okay, and just put those aside for the moment. So they have to be conducting professional credentialing or quality review activities involving the competence or quality of care provided by a healthcare provider. And that's going to cover both an individual and an entity. Okay, so this seems pretty straightforward. Then Nebraska defines a healthcare provider as a facility that's licensed under its licensing act, a healthcare professional that's licensed under the Uniform Credentialing Act, and Nebraska has a Uniform Credentialing Act, so that would be licensed professionals, or an organization of healthcare professionals. So presumably that's like maybe a bunch of doctors getting together, so I guess a thing like a clinic maybe. But remember, that's how we define a healthcare provider. Let's go back to what you need to be. You have to be a governing board of a facility. Here we talk about a healthcare professional licensed under the Uniform Credentialing Act. Is a healthcare professional ever going to have a governing board? Do you meet both parts of that? Ooh, that's really sloppily done. Then it gets potentially even harder. So what's a facility in Nebraska? A healthcare facility means an ambulatory surgical center, was a long list, but I'm going to focus on a health clinic. So if you had the question, can a clinic do peer review in Nebraska? Now, this is the straw man I'm building, okay? The answer, I think, is yes, and I think the answer is yes because of the organization or association of healthcare professionals licensed here. So I think the answer is yes. bear with me as I build a straw man in the importance of looking at definitions in statutes. And this is a lesson I want to apply to both lawyers, especially young lawyers, and also people who occasionally pick up statute books and figure they're going to read them and figure out the law. This is how you can go really, really wrong. So a facility is a health clinic. Well, that seems straightforward. Clinics are in. Oh, it turns out Nebraska has a definition for a health clinic. And a health clinic doesn't include a healthcare practitioner facility unless the facility is either an ambulatory surgical center, or it does abortions, or it does hemodialysis and labor. My head's going to explode right now, all right? So a clinic isn't a healthcare professional facility, all right? But a healthcare practitioner facility means the residence or office of a clinic or a group of practitioners. Oh my God, this is hard. Now, remember, I'm making this harder than necessary in the sense of here, I do think a clinic can do things. A solo practitioner, it's not nearly as clear because I don't know that you have a governing board. But this is really hard. And the state statutes, a lot of them are like this. And the lesson I'm really going with is you have to chase it down. And if you see a phrase like clinic, you can't assume that what you are is a clinic, because clinic might be defined as something with a very specific and weird license. And so you need to pore through the entire set of statutes to understand this stuff. Okay, moving on to another state to just highlight some of the weird things that happen. So South Dakota. So South Dakota handles hospitals and clinics differently. So a peer review committee is one or more people who are acting as a committee, and if you're at a licensed healthcare facility, you're okay. Okay, so it's one or more persons, just any people. But a committee comprised of physicians within a group medical practice. Okay, so let's see if I can put this into plain English. One or more persons can be a peer review committee in a hospital. So you could have an administrator, and they can be part of the committee. And it isn't obvious because it doesn't say it in the same way, but if you read the statute carefully, see how the committee has to be comprised of physicians if you're in a clinic. Huh. So it's kind of sneaky, but there's at least an argument that if the administrator is on the peer review thing in the clinic, that's going to destroy the privilege. Whereas a hospital director of nursing sitting on the hospital one is okay. Does this make sense? Not really. It's a nuance in the weird state law. But here it gets a little clearer in the blue. For purposes of this section, a peer review committee is one or more persons acting as an administrative or medical committee, a department, section, or board of directors of a licensed healthcare facility. All right? So you really have to dive in. Now, Minnesota handles things differently. So Minnesota says that the membership has to be limited to professionals, administrative staff, and consumer directors, because the consumer directors is something you see in an HMO. So here you could have an administrator from a clinic be on the committee. Now, next question in Minnesota, can the lawyer show up at the peer review thing? Well, that's an interesting question. Are we administrative staff? And is the answer different if I'm an in-house lawyer for the clinic? Feels like that's administrative staff. Well, if I'm the outside lawyer, does that make me no longer administrative staff? I don't know the answer to this. I'm tossing it out there. It's not clear. And in each state, you're going to have to kind of look and figure out how that's going to play out. The Iowa statute. So it's weird too. So it says that a peer review committee is one or more people who are acting in a capacity to serve as an officer, director, trustee, or member of any of the following. So I guess what they're thinking of is if in a clinic, the doctors are, if you're not on the board, you're a member of it. That's not a phrase I would use, but that's how they get at things. Is the administrator in Iowa a member? I'd say yes. But you have to know if a plaintiff is trying to get peer review stuff, that's the wiggle room they're going to go with. If the administrator sits in, they're going to say that person isn't a member of the organization. Okay, so some procedural questions about, or strategic things about how to handle peer review. So do you wait until there's a problem, or do you do them randomly? There's not a right answer to this. I guess I am a fan at looking at some things randomly. The protection's going to apply either way. You don't need a problem in order to have the peer review protection. And so compare that, people often want attorney-client privilege for reviews, okay? And so maybe you'll have a coding review done. Well, if you do a random coding review, that's not privileged, most likely. I shouldn't say that as clearly, because there's an argument it's covered under the self-examination privilege or something like that. But it's going to be hard to use work product because that's only covered in anticipation of litigation. Peer review is a different critter. So you can do, and you just say, we're going to look at 5 charts for every doctor, and that would be protected, and you're free to do it. And there's really no disincentive to doing that. When do you use a summary suspension? I think that's one of the very difficult questions that comes up. And the reason it's so difficult is that the act of suspending someone is a really big deal, and you arguably create an ability for that person to claim you've defamed them in some way. And so if you do it willy-nilly, and I went through a rash, it hasn't happened to me lately, but there was a period about 2.5 or 3 years ago where I had 4 summary suspensions on my desk at the same time, where in those I was representing the physician. And I was shocked at some of them that the person had been summarily suspended where no patient had been harmed, and I couldn't figure out what was going on. And that seems to have calmed down right now. I don't have as many of those on my desk at the moment, but it's happening out there. And in several of those instances, the organization paid the doctor a boatload of money because it acted rashly. So I am not a fan of the summary suspension unless you think people are really in peril of dying. And remember, as soon as you call something an investigation, that has potential ramifications. If the person resigns during an investigation, that might be reportable. And if you're trying to figure out a way to part ways amicably, as soon as you've called something an investigation, you might be making it harder for the person to quit, especially if it's quitting your medical staff in the hospital setting. Now, and you don't want to be, but remember now, if you're too cute and you avoid calling it an investigation and the person leaves and they then go have a bad outcome someplace else, that patient may potentially have a claim against you for not sufficiently dealing with the problem. So this stuff gets hard. You're going to be balancing employment liability against potential malpractice liability. Now, from a practical standpoint, you're more likely to have insurance coverage for that patient liability, which is one good reason to go out and buy decent employment practices coverage and then make sure it's actually good. Can you use peer review for behavioral issues? Well, the Healthcare Quality Improvement Act, remember, the way it carves stuff out, it's not so clear. You'd have to argue it's professional competence related. Some of those are clearly in there, but some of them are going to be a lot fuzzier. And being rude, remember, supervision of staff is specifically carved out of the Quality Improvement Act. In most states, I would say, yes, you can use it for behavioral issues. Remember, you're not going to be getting any protection in most states relative to the person. So if you fire someone for bad behavior, you're still going to have to show them in almost every state their peer review file. The thing you'll be protecting is you won't necessarily have to give it to a patient. If a patient brings a claim and says the doctor was a jerk to me, not usually the basis of a malpractice suit, it might be protected. I suppose the bigger one would be some sort of sex allegation there. You might be able to protect other harassment claims if they went through the peer review protection. Now, you'll have to figure out if your state is going to consider a doctor hitting on a nurse as something that's protected, or a doctor hitting on another doctor. In a lot of states, that won't meet the statute. Can you use peer review for your hiring process or for evaluating a new employee? You can. Hospitals basically have to, in some ways, do that. When do you tell the person they're being reviewed? Another really good question, and there's no clear answer to it. If you're doing random reviews, do you say before, hey, we've pulled 5 of your charts, or do you look at the 5 charts and then tell them the results? If you tell them they're the subject of an investigation, remember, leaving becomes more complicated. If it's a random review, I think it doesn't really matter. There's a giant psychological component here, so I tend to like to get to a point where I really think there's a problem before I tell the person who's being reviewed, because I think that there's a psychological component in there, but this is a place where reasonable people could differ. So who should do the investigation? This is where you need to understand your state law, because it may be that you need to use a licensed professional to do that. a key thing, avoid using competitors and rivals. I was involved on a hospital side of one of these things where everyone said, hey, we all trained under Dr. X. Let's use Dr. X to do the review. Well, Dr. X knew all of the parties. And the newest doctor, who was the one who was being reviewed, thought that Dr. X didn't like her. And so when we got the review from Dr. X, the doctor is saying, wait a minute, Dr. X doesn't like me. Dr. X doesn't like women. Dr. X doesn't like young people. This person had all kinds of beefs about Dr. X. I, to this day, don't know whether those beefs were legitimate or not. I know they sounded, to me, they sounded plausible. And I know that there were two important things. One is that meant that the doctor wasn't going to take Dr. X credibly. And two, if we ever got in front of a court, it was going to be hard to convince the judge that Dr. X was objective. And so I am a fan of the anonymous review by someone who doesn't know the players. So actually what I'm a fan of is you carve your review into two pieces. There's your cursory initial review. Do we have a problem? If that first review says there's a problem, that's when before you take any drastic action, you get other people involved and you turn to someone with fresh eyes, ideally geographically removed, and say, look at this. That can help you in any sorts of allegations that the review is biased. Obviously, you have to make sure that you've got people with the right subject matter and expertise. I am stunned when I see, cardiology reviews being done by non-cardiologists, or OB reviews done, by a family practitioner. And yes, family practitioners can deliver babies. That's totally true. But if I'm going to suspend an OB, I'm not going to do it off of a review by a family practitioner. Which isn't to say that I wouldn't have if I'm in a small clinic, I might have that family practitioner take a first cut and see if I think it looks bad or not. But then it's going to an OB. So having another member of the same group do the review is potential peril. I had another fight, this one I was representing the doctor, and holy cow, this was a mess. They were looking at the former partner did the review of their ex. There'd been a bad breakup. And, so the hospital was relying on the opinion of the former colleague to go after this doctor. Okay, yikes. What's happening now? We have lots of big hospital systems. You're a big hospital system. You've got 3 hospitals across the state or in 2 states. Is it okay to use someone who's employed by you in another state? It's cheaper. Once again, personally, I'm much happier with that as my first cut. If I'm getting rid of the person, I am going to want an opinion from someone who's not employed by the system, because it's going to be pretty easy. If I'm defending the hospital, I'm going to want to get an outside person. If I'm defending the doctor, I'm going to make hay out of the fact that the expert in this case is captive. And so I'm definitely going to try to have an opinion from someone who's outside. What about programs like CPEP, which is a program in Colorado? It's pretty well known, and they'll evaluate physicians. That's great, but I've seen this happen. You send the doctor to the program says the doctor's okay, and you still want to get rid of them. That's a disaster. I represented a doctor for whom that happened. The hospital, sent him through the program. Program said no big deal, and then they suspended him. That's shooting fish in a barrel, because you've picked an objective outsider, and the objective outsider has said things are okay, and now the former competitor says they're not, and you trust the former competitor over the objective outsider. So think about this. Before you send out a review, if you know you want to get rid of a physician, to me, you may not want to do a review. Just get rid of them. Because if the review comes out the other way and you get rid of them, that's not going to go well. What do you tell witnesses in a peer review? I'm a fan of being fairly straight up with people. I think you tell them the truth, and you make it clear that they understand that they can be honest and that they've got the protection of that federal law on their side, and that they can be honest without fear of any sort of liability. In fact, that becomes a really important thing, because I think people are often really worried about retaliation from an employer, and they're scared to come forward. And so emphasizing that under federal law basically says that if they're acting in good faith and they're not consciously lying, they can't get in trouble for defamation. When do you involve counsel? Well, early, and that sounds self-serving, but the decisions you make early on this set up what's going to happen later. And I can tell you all kinds of stories. There's a case I won. This is when I was, so you can tell I'm on both sides on this. I represent physicians and hospitals. So representing a physician in a dispute with an insurance company, and we did a hearing, lost the hearing, and we wound up winning ultimately because the insurance company failed to record the hearing. And their hearing process required a record of the hearing. There wasn't a record of the hearing. I noticed while I'm sitting at the hearing table, I'm like, oh, they don't have a recording of this. And I just sat quietly and waited. And then when we got a bad result, I said, I want a copy of the hearing. And they said, well, we don't have a copy of the hearing. Poof, that's it. It's like the hearing had never happened. There are all kinds of traps in here. Actually, representing the hospital or clinic in this is scary as a lawyer because it's really easy to mess this stuff up. It's a lot easier to snipe later. And because of that, you want to get your lawyer involved early, not to spend gazillions of legal dollars on it, but just to set up a process that's going to be defensible. Can the subject involve counsel? And this is an interesting question. There are competing theories on this one. So especially in the clinic, if you're doing an informal thing in the clinic, you could say it's not a hearing. So this isn't true in the medical staff context where it is a hearing, but like the clinic, if you're choosing not to use the Healthcare Quality Improvement Act, you can say it's not a hearing. We want free-flowing information. Don't let them have counsel. I am strongly on the other side here. I think, why are you afraid of letting someone bring a lawyer into this? I mean, I have several thoughts on it. First, I want them to feel confident, and they'll feel better and less likely they're being run out on a rail if they can bring a lawyer. I figure if I'm representing the clinic, I can keep that lawyer under control. If they want to bring up a bunch of other stuff, I can handle that. That's not a big deal. And I want the person to feel comfortable, and I want them, if we fire them, to be able to say we afforded them every possible piece of due process. And so I'm going to bend over backwards, and I'm going to let them bring a lawyer. If they want to submit something, I'm going to take it. You aren't a stickler on rules on the clinic or hospital side here. You're flexible because you want to be fair. Wisconsin has a provision that kind of describes this pretty well in there. So they say if a member of the reviewing organization has acted in good faith, the court will consider whether the member sought to prevent the healthcare provider and its counsel from examining the documents and records used in the review, or from presenting witnesses, establishing pertinent facts and circumstances, questioning or refuting testimony and evidence, confronting and cross-examining adverse witnesses, or from receiving a copy of the final report or recommendation. I think the Wisconsin law on this is great, and it's kind of saying, look at the gestalt and try to figure out were they giving the person being reviewed every right they could. And I, if you're not in Wisconsin, would still kind of look at this Wisconsin provision and say, live up to it. So can a peer review organization can peer review committees share their information? This is totally a state law question. So I stuck cites for 3 states in there that clearly allow sharing. Kansas, crystal clear. North Dakota, crystal clear. Wisconsin, well, they allow the person who authorized the review to share it with the subject's employer, but they don't necessarily allow stuff more broadly. In states that allow it, I am a fan of going committee to committee and not person to person. And so, practical issue, you've got a clinic peer review committee and you've got a hospital peer review committee. And a doctor let's make this cardiology. A cardiologist sits on the hospital peer review committee, and they see that they're reviewing. So I'm on the committee, and I see they're reviewing Katie. Can I walk into the clinic and say, hey, we're reviewing Katie? Well, it's not clear that I can. In some states, it's pretty clear you can't, actually. But in states that would allow it, rather than having me go to the clinic, I would have the chair of the clinic say to the chair of the clinic committee, we're doing this review. But once again, you got to know your state law and whether it allows sharing that information. So incident reports. A handful of states explicitly protect them, Wisconsin and Nebraska. One of my colleagues, Dave Bundy, had a case here where it was really fun. We protected an incident report. And I think they should be protected. I think that the best way to do that is to have a form that's created by the peer review committee and sent to the peer review committee. And what I'm arguing then is that the form is really a surrogate for the committee. And so just as you could send a member of the committee out to conduct an interview, you can send a form out on their behalf. And now, to make this work, you'd want to treat your medical incident reports differently than you would treat an incident report for a slip and fall or a food poisoning or some other non-medical thing. It's got to be a different process with a different form. So the question to think about is, are you being fair and are you being consistent? If you're treating other practitioners differently, that's going to be something people use all of the time. They're going to look at every review you've done before. Are your actions in the review consistent? And I'm going to put consistency aside to kind of work it into reporting, because this is, I think, the area where consistency is often the biggest problem. So imagine the following scenario. You've got an issue with a doctor's behavior. You think they're doing something poorly. But everyone likes the doctor and they don't want to be mean to them. So we give the doctor a slap on the wrist of some sort, and we opt not to report them to anyone. Okay? Now, later we fire the doctor and we say that the thing we did, that the doctor did before, was really a big deal. And, we think it was really important. What's the first thing the doctor's going to say, if the lawyer's going to say if they're smart? Well, did you report them to the board? And if the answer is no, they're going to say, well, then you didn't think it was a big deal. If you thought it was a big deal, you'd report them to the board. And this kind of goes into the no good deed goes unpunished theory of life, a theory I don't believe in, but this is one where you have to be really aware of your consistency, because there's some consistency is bad. You might fire one person for behavior that you didn't fire someone else, and the reason is that the other one has 6 other problems too. That's not the kind of consistency you need. But if you think something's a big deal, you've got to report it. Or in most states, you're going to have a duty to report certain disciplinary actions to the board. And you need to look at your state board, the National Practitioner Data Bank. If you're a hospital and you take any disciplinary action, you're going to have an NPD reporting thing. Your insurance contract might require you to report. Your ACO contract, notice those things. They might have a provision in there that says that if you take any disciplinary action against a physician, you have to tell them. You might have to report to the hospital. It's more likely that the doctor has that duty through something in like the bylaws or something than for the group. Generally, groups don't have agreements with the hospital that's going to require reporting, but it's possible. And so this is, to me, a really big deal. And especially that not reporting to the board to be nice to the doctor coming back to bite you is one I see a lot. Okay, just a few more slides here on, so quirks that are, this is one of the things that we've learned in the peer review stuff. It is unpredictable. And part of it is courts often don't like protections or privileges, and so they'll find reasons to let stuff in. Peer review seems a little different. Actually, I do see courts often protecting peer review, but here are some cases that make you go, wow. So this was an Iowa case where the risk manager having the records meant that that was outside the peer review process. They kind of focused on that member thing, and you go, that's insane. But that's what that court ruled in 2010 in Iowa. There was a Nebraska case, and you'll see in the next two, the law is subsequently changed, and that's often what happens is you get a weird result, and then the law changes. But so in that one, a doctor wanted to prevent a plaintiff from getting the record of his disciplinary proceedings, and the court said that the doctor didn't have standing to assert the privilege because the doctor wasn't the holder of the privilege, the facility was. Nuts. And that resulted in a change in the law. But one of the lessons here is you get weird results. Reading peer review cases, it's harder to predict the results in my mind than in most other cases. This was a Wisconsin case. So there's a letter between two chair people talking about a resident. This is in an academic program. And they said that those letters weren't protected because it wasn't initiated or performed at the hospital's peer review committee. And the intent of the letter was for the narrow purpose of reporting problems and concerns about the resident and was not intended for the broader goal of improving the quality of health care at the hospital. Huh? That's another one Wisconsin law changed. I read this case and went, how'd they get there? I don't understand how they got there, but they got there. So, last thing, who do you tell? So, like, let's say your peer review process decides that unnecessary services were performed. This highlights that while your process may be protected, the results often are not, because if you reach a conclusion, that conclusion is going to trigger potential reporting duties. You may have a duty to report to patients, payers, future employers of the board. If you think something is wrong, peer review protection doesn't mean you don't have to act once you've reached the conclusion. It's going to protect disclosure about how you reached the conclusion. But if you decide unnecessary services were provided, I think there's certainly for Medicare a legal duty, and I'd argue there's probably for private payers a duty to let them know. I certainly would recommend letting them know. I'd want to let the board know. Frankly, in the current world, you're going to have a defamation issue that you're worried about, but I'm going to seriously think about letting future employers know. The future employers to me is the hardest one. That's the one I'm going to get anxiety about deciding. All right, I've prattled on for an hour here. I don't know if we've got any questions. So far, I don't think any have come in. I've lulled everyone into sleep. So I will close by noting that the next webinar, remember, is our grab bag about electronic health record stuff. Funnier people than I will be doing it. So it's Breyer, Katie Ilton, and Jim Platt. That's February 11th at this time. And this and all of our other webinars are available on SlideShare, and they're there for free, so if you care to be bored. Thank you so much for listening in, and happy almost Ides of January.